know what, I didn't ask that, so I don't know. And they gave me a little question. And then she said, Miles Garrett, the teacher from Valley, he was very less.
Let's go back. Yeah, the screen's not there. Yeah. Yeah, let's chat. So how's it going? More jacket.
More sweater and a jacket.
Yeah, me
I
too.
don't know what it's going to be like. See what she says.
I'm trying to find Johnny in the car. That's exciting.
Oh, I'm so sorry.
Yeah.
They get one of the last of the kids.
Oh, did they?
I know. I
He doesn't want it.
They're awesome to drive.
Yeah.
And you sit up higher from your car.
That didn't even come.
We're looking at Chevy tracks today or tomorrow.
That's what happens.
Oh.
Right across over SUV. I think it's a
He
Grand
loves
SUV.
it. Yeah.
He had a 97 Buick that
He could fit all of his stuff in.
97 Buick.
It was all later out.
Big body.
We had an LTD. Do you remember LTDs?
Yeah.
It was a boat. Like I looked at your little head sticking out. Like, why are you guys getting the biggest car? It was a driving it.
Oh, shit, you got tissue already.
Yeah. Yep. Just very good.
Oh, I'm gonna get some from them.
Yeah. Stick it in my pocket.
Oh, on that one? They usually don't play it.
He's got too much hardware.
Well, Ernie does.
Do you have more?
Yeah,
I didn't have one.
That's why it doesn't make sense.
Yes. Okay.
Prosecution side,
They're not that small.
But yeah.
We'll see.
Over here.
Thank you.
I'm just checking that.
Okay, we just wanted to make sure, so.
Thank you. I appreciate it.
I was one of the last people.
thank you. May be seated. All right, good morning. We're here for sentencing this morning. Just a couple of reminders. I'll ask to make sure that those of you who have cell phones that are allowed in the courtroom, that they're on silent for me, please. With respect to sentencing, I'll just note to all of you present here this morning that there are certain things I'm required to do as a judge that is told to me by our legislature as well as the higher courts, Supreme Court and Court of Appeals. And I'm going to address those aspects first before I go into the sentencing discussions that we'll have here on the record from the state and Ms. Ellis and her lawyers, and then my comments. So please bear with me as I comply with the procedural requirements in order to satisfy some of the due process that Ms. Ellis is owed here this morning. So with respect to a number of items that I'm going to address this morning, the first would be that based on the verdict that was handed down, and why don't I go through again just for the record. It was a 10-count indictment. I had dismissed one count during trial. The jury had returned a verdict on case 692604 of guilty of all the remaining 9 charges. Those 9 charges, count 1 being the aggravated murder, count 2 being murder under the A section of the code, count 3 being under the B section of the code. Count 4 was felonious assault, as well as count 8, endangering children, guilty verdict. 2 counts of attempted murder, guilty verdicts. And then finally the last count, which would have been count 10, which was the theft charge, the misdemeanor. Having found and rendered a verdict of guilty, the jury brought forward the requirements under the statute. One is that there is a duty to advise Ms. Ellis of a violent offender being found guilty on the aggravated murder of some reporting requirements that she's to report in the event that she's placed back in the community. So Ms. Ellis, I'm going to address you on a few items that need to be addressed with you before I go into the sentencing phase. Ms. Ellis, you've had an opportunity to meet with your lawyers before coming out this morning. I have provided them the duty to enroll as a violent offender. I know they spoke to you about it, and I'll go through it just briefly. Your signature is on that form from this morning as well. And so I'll just ask you, Ms. Ellis, did you have a chance to speak to your lawyers about this duty to enroll as a violent offender this morning? Did you have a chance to discuss that? And did you sign that today?
Yeah.
Very good. Being convicted or being found guilty of this offense of aggravated murder, you are required to enroll in person with the sheriff of the county in which you establish residency within 10 days of coming into that county. You're going to have to provide that sheriff a number of items: your Social Security, full name, residence, the information regarding this verdict from the jury, addresses of employment or school, driver's license information. All of that's required to be provided if given that opportunity to be back in the community to the county sheriff. You're required to provide fingerprints and palm prints, and after the date of initial enrollment, you're required to re-enroll annually as well. And that's something within 10 days of the anniversary that you sign initially with the sheriff. If you change any of your addresses, you do have to provide written notice to the county and the sheriff as well. Failure to do so, you could be charged with additional felonies by the prosecution. And having reviewed that with your lawyers, do you understand that, Ms. Ellis?
Yes.
All right, very good. I'm going to go ahead and sign. With respect to some other requirements that I'm required to advise you of as well that I want to make sure I do before I hear from all the parties. So with respect to your verdict of guilty that was found regarding count 6 of the indictment, and for the record, for the parties, for the state, and for counsel for Ms. Ellis, The finding of the jury on counts 6 and 7 were both felonies of the first degree. I'm going to use count 6 with respect to sentencing guidelines, the felony of the first degree regarding Reagan Tokes notification. So because it's the first felony of the first degree of which the jury returned a verdict, is there any concerns with that? Ms. Fralia, I do have to still advise, still understanding that count 1 will be controlling regarding sentence.
Correct, Your Honor. The state was going to elect on count 7 and have count 6 and count 8 merge into count 7. And we were going to elect on count 7 for sentencing purposes.
So with respect to count 7, so let me just make sure. Okay, so count 7, the felony of the first degree, the court will advise Reagan Tokes. Any objection from the defense?
No, Your Honor.
And then all other Reagan Toke sentences will merge into that. So, Ms. Ellis, the legislature has put in an indefinite sentence that I have to advise you of regarding this count. Now we've agreed count 7, the court will move forward on regarding Reagan Tokes sentencing guidelines. I know for some of you here in the courtroom, you'll say, why is he doing this? Well, to protect, again, due process and to make sure that I protect the record for the Court of Appeals. So let me just advise you, on count 7, the sentence anywhere ranges from 3 to 11 years. Under the Reagan Tokes sentencing guidelines, we'll go to the highest sentence and explain that. Under the highest sentence of 11 years, our legislature has now implemented an indefinite sentence. That indefinite sentence is really a mathematical equation. So if you take the 11 years and divide it in half, you then add it back to the 11 to give the sentencing range. So with respect to Reagan Tokes and count 7, the maximum sentence you could receive is 11 years, which is the minimum, to an indefinite sentence of 16 and a half. So dividing 11 is 5 and a half. Adding it back to 11 is 16 and a half. So I'm advising you, Ms. Ellis, the sentencing range on the maximum sentence with respect to count 7 will be 11 minimum to an indefinite sentence of 16 and a half. So do you understand that? Okay, now I'll just read the requirements that the Court of Appeals has asked me to read. So I'll read it to you because I have to read it, but then I'll answer some questions if you have any. For purposes of just this count and all of the other sentence being merged into count 7 for Reagan Tokes, it's presumed, Ms. Ellis, under the law that an offender is going to be released at service of sentence at the expiration of the minimum term. So if it was the only sentence you were receiving, it's presumed that you would be released at the 11 years, if in fact that's the highest sentence that you receive, and any of the other 3 to 11. It's presumed also that you serve no more than the indefinite sentence. So the maximum I told you was 16 and a half. So that range, and the law says you should be released at the minimum, but you shouldn't serve more than the maximum indefinite sentence. If the parole authority is going to have a hearing to keep you longer than the minimum, they have to place on the record during that hearing, it's a hearing held at the Department of Rehabilitation and Corrections. They have to outline conduct, which is considered reasons why you should stay longer than the minimum, whether you participated in any rehabilitation, your threat to society, and your restrictive housing, if any, while you have been confined. Ms. Ellis, they have to notify you of the hearing. The hearing is then held with you being present before the Department of Rehabilitation, and then those items that have to be presented to overcome that presumption that you serve the minimum sentence. And finally, they can do it more than one time. So the department may make the specific determinations and maintain your incarceration beyond the minimum sentence more than one time, and they can have multiple hearings, but every hearing they have to have you present and present that evidence that they wanted to present on why you should stay longer. So do you understand those, how that affects a Reagan-Toke sentencing? Okay, thank you. And then finally, the last advisement that I have to advise is post-release control. Even though we have a life sentence with parole eligibilities that I will consider today for sentencing, I still have to advise you that on the felony of the first degree, under all felonies of the first degree, they will be controlling with respect to post-release control. Ms. Ellis, post-release control is supervision by a parole officer. Here in our state, under felonies of the first degree, you have a mandatory minimum of 2 years that you have to report, up to a maximum of 5 years. That will be imposed upon you if given the opportunity to be placed back in the community. You'll have the ability then to report to a parole officer, and you would have to follow all their terms and conditions. If you violate parole, which is also known, again, I keep saying parole, it's post-release control or PRC, our parole board has a hearing, and they can determine if you're in violation, and they could send you back to prison for up to 1/2 the time you served for me, or a minimum term imposed upon you in 9-month increments. If you're on post-release control and pick up a new case and convicted of a new felony, the new sentencing judge will have the authority to terminate your post-release control or order a consecutive term up to the greater of 12 months or the remaining period of post-release control. Again, those are advisements that in order to have due process, I have to note for the record, and I believe I've satisfied the Reagan-Toke requirements, the requirements regarding post-release control, and the requirements regarding the notation of the reporting under the act regarding her violence under aggravated murder that she has to report to. So that being said, let me just go back to the state of Ohio. Are there anything that you believe I may have missed regarding the mandatory reporting requirements that I needed to place on the record today?
No, Your Honor.
And then on behalf of Ms. Ellis.
No, Your Honor.
Okay, thank you both. All right, that being said, again, here for sentencing, I'll just note for the record that hearing from the parties this morning, I also received some letters from the general public, and a couple of those were not noted with names, but I wanted to make whoever the general public is that sent letters to me that I did review those prior to today's sentencing as well. And so I'll ask from the state of Ohio if the state would like to place on the record any comments regarding sentencing before I hand down a sentence here this morning.
Thank you, Your Honor. Yes, we do. As you notice, I also have the North Olmsted Police Department members of that department are here as well. We're going to begin this morning with Mr. and Mrs. Wood would like to address the judge.
All right, very good. I think we're going to have the podium, just so you could stand where you're at. We'll have you do that. We'll have Mr. Toms put it there. Good morning.
Good morning, Your Honor.
And I'll just note, I do have the microphone on. If you could just speak loudly and clearly, take your time if you're going to read from something. If you don't mind just stating your name for the record and just spelling it for the record.
All right, well, my name is Jared Wood, Jared Wood.
Very good. I'll ask the advocate maybe just to push that up a little.
Is this better?
Sure.
All right.
And thank you. I'll hear from you this morning.
Oh, thank you. I am here today to speak on behalf of my son, Julian Miles Wood, who is no longer here to speak for himself, and I am thankful for you to be able to be giving me this opportunity to do so. It's hard to know where to start when talking about him, so I guess I'll start with letting you know that our family is no stranger to the struggles of cognitive or behavioral differences. Our oldest child has autism. He was actually considered nonverbal, and it wasn't until he was about 7 years old when he became verbal. We tried everything we could to help as parents, but who I should say, actually got him to break free and open up and talk to the point to where we have actually a hard time getting him to stop now was Julian himself. Julian had a special way with people to get them to grow and open up and just have fun. That was the kind of kid he was. He was funny, outgoing, fearless, and full of life, love, and laughter. The energy he brought to the world was boundless. I even called him my copper top baby because his hair wasn't as quite the same color as red as mine, but it was more of a copper color like the battery. Julian loved dinosaurs, and outside of saying hi, Mom and Dad, dinosaur was his first word, which actually shocked all of us with how big of a word it was at such a young age. He also loved Halloween, so much so that he chose to be a dinosaur every year without fail, and he would even find his old costumes throughout the year and put them on even though they no longer fit, not letting us take them off until it was bedtime, where we would have to put on his dino pajamas. However, these are moments that we'll never get the chance to share with him again. Julian had a way of letting you know he was near, like when he woke up in the morning, usually before daylight, with his thundering footsteps as he walked down the hallway from his room. That is when I knew it was my cue to get up to go get him some leche, which is milk. Another way Julian made his presence known was by taking his brother's toys and running around laughing because he knew he couldn't catch them, and it was funny to take big brother's things, which unknowingly helped his brother find his voice and start speaking up for himself. He always knew when you were down or feeling some kind of way, and he would do in his own way what he felt you needed to feel better. For me, when he felt I was down or had a rough day, he would get his brother and they would tag team wrestle me and just beat me up. We would roughhouse a little on the bed here and there, and he would also run into the kitchen whenever I came home from work to greet me. Sometimes I would tease him by hiding behind the doors, and he would look stumped to where I was. And I would jump out roaring like a dinosaur, and he'd roar back and then punch me in the stomach and go, "Ah, you scared me, Dad." For my wife, he would snuggle deeply and tell her he loved her. And sometimes he would fearlessly climb onto the counter and go into the cabinets and pull out a box of cake mix and help her make a cake. And for his grandmother, he was glued to her side. They had their inside jokes. He learned to love all the odd old candies like black licorice or candy corn. And for his brother, he would sit with him and watch videos on his iPad so Big Brother knew he was near. He was just so smart and funny and knew things that most little kids didn't know. Like whenever we would go in the car, he would always try to give us directions to McDonald's because he always wanted French fries. Another thing he always wanted to do was help us with errands. If he saw me or my wife putting on our tennis shoes, he would run and put his shoes on and wanted to go and just to spend time with us. Now, these are things we will never get to do with him again. What I am most sad about now is not just the time I don't get to spend with him, but the time his brother, his sister, his mother, his grandma, and all of our family that doesn't get to spend with him with the time again, and we are all robbed of that opportunity. He was on a path to be a big kid, which is why I called him my big guy too. He was going to be the protector of his brother and sister. That part was evident since the moment I brought Julian and his brother to the hospital to meet the new baby sister and see their mother. Julian was so in love with her. He wouldn't leave her alone or take his eyes off her while we're there. And he even tried feeding her while she laid in the crib sleeping. his sister won't get to know the amount of love he had for her, other than from what we tell her. She didn't even get a full 2 months with him before he was taken from us. When we had our daughter, I finally felt I had a full life. I had everything I ever wanted. A beautiful, loving wife, 2 sons and a daughter. It didn't even last all of 2 months before that monster took him from us. Now all of our hearts will forever be missing a piece, and it's up to all of us to keep his light shining, even though his star is gone. With that, I would like to thank you for taking the time to hear me out and speak about our son and what he was able to give this world in such a short time. And thank you again to the prosecution, Anna and Julian, for fighting so hard for our boy and my wife. And thanks to the jury for getting it right. And thank you to the North Olmsted Police Department for all the work you guys did with helping on that day. And to the community for the continued support. We will be forever grateful. With all that being said, to Judge Russo, I ask you to do what's best for my family and the community, so she has no opportunity to commit these heinous crimes again. I'm asking you to give her the maximum sentence possible, life without parole. Thank you.
Thank you. Good morning.
Good morning.
I'll hear from you, Margo.
Did I say my name?
Well, sure. I'm sorry.
My name is Margo Wood, Margot. I watched my son take his first breaths when he was born, and I watched him take his last in my arms, covered in his blood. A mother should never have to bury their child. A mother is supposed to go first, not her children. A mother shouldn't receive her child's death certificate at 3 years old, and his cause of death is by homicide. That woman murdering my son replays in my head every single day. It is my living nightmare. The last thing I will ever hear from my son is his scream, the sound of his pain and fear before he was gone. And I can still see the terror in his eyes, and it haunts me every day. He was my baby boy, and the day he died, a part of me died with him. My older son has autism. He doesn't fully understand why his little brother, his best friend, isn't here anymore. He asks us about heaven and if we can just wake up baby Julian so he can come home and be here with us. He thinks if he goes to the hospital, he can go and see him. When his dad goes to run an errand or leaves for work, my son worries that he won't come home. I have to call my husband on video chat so he can make sure his dad isn't dead. The days Jared and I were here for trial, he thought we both died. So my aunt and my mom had to reassure him that we were okay and we would be home later. When his friends or teachers at school are absent due to being sick or having appointments, When they come back, he runs to them and gives them a big hug and yells, "You're alive." You have not only hurt me, you have not only taken away my youngest son, you have caused trauma to my other children. My daughter was only 2 months old when she killed my sweet boy. Julian gave his sister all the love and affection a big brother could ever give in that short time. Coming home from preschool, he would take off his backpack and run to give her a big hug and a kiss. He helped with bath time, stood next to me during diaper changes, and would help with giving her a bottle. They were like two peas in a pod, Velcroed together. Wherever she was, he was right next to her. My daughter is 18 months. And now she only knows going to the cemetery to see her brother. She will never get another hug, a kiss, or a cuddle from her older brother. He is now just her guardian angel. She will never know how much he loved her and how happy he was to see her when she was born. Only the stories that we tell her. Julian brought laughter, light, and love in our home with his infectious laugh. He helped with my oldest son in so many ways with communication and play. Our home isn't as loud and chaotic anymore, not the way it used to be. There's no one playing with dinosaurs and chasing around his big brother with them. My boys aren't wrestling in the living room and dancing to the Minions movies. There is no one dressing up for Halloween as a dinosaur. My son would have been 5 in 2 days. She took that from us. She took birthdays, holidays, milestones, graduations, seeing what kind of man he would have turned into. No grandchildren, no nieces or nephews for his siblings. When you murdered him, you took those potential lives, moments, and memories from all of us. If I want my family to be whole, we have to go to the cemetery where all of my children can be together. My oldest doesn't like going because it makes him sad. Now when I take pictures of my son, it's just his name on a wall, surrounded by flowers and dinosaurs that people leave him. Instead of taking photos of him making funny photos, cute smiles, or laughing pictures. I hate you with every fiber of my being. Because of you, I live in constant fear. For months, I couldn't leave my home. If I did leave my home, I needed someone by my side, and even then I was stricken with fear. I don't take my children to the store by myself anymore because I fear something might happen. I leave my kids at home with my mom and go by myself because if anything happens, it'll just happen to me. I hate that I'm here and my son is gone. Just because you have a mental illness doesn't mean you can use that to justify you murdering my son. What you did was unforgivable, and it can never be taken back. You deserve to go to jail for the rest of your life, so you can't hurt anyone else. You don't deserve a second chance. You don't deserve mercy. You didn't give my son any. You belong in prison where there is no chance of you getting out. The jury got it right when they read the verdict that you were guilty on all counts. It felt like the first time I could actually breathe in the last 499 days. Because I knew in my heart that you were going exactly where you need to be. in prison. You don't deserve the luxury of a mental facility where you can earn privileges and possibly be released back into the world. That's too good for you. The world is safer with you behind bars. Judge Russo, I urge you to give her the maximum penalty without parole, so she has no chance of hurting another innocent soul like my sweet baby boy Julian.
Thank you. Ms. Feralia?
Yes, Detective Sean Ventris from the North Olmsted Police Department is going to speak.
Morning, everybody. Good morning, Your Honor.
Morning.
I'm just going to leave this tilted if that's okay.
Sure.
My name is Detective Sean Ventris, and I'm with the North Olmsted Police Department. First name is spelled S-E-A-N. Last name is V as in Victor, E-N-T-R-I-C-E. I speak today on behalf of every officer and staff member who was involved in the investigation of the murder of 3-year-old Julian Wood. No amount of training can prepare a police officer for the loss of a child. This case has left a lasting emotional impact on everyone who responded that day. The officers who found Julian Wood will never forget what they saw, the innocence that was taken, and the silence that followed. For many, it is an image and weight they will carry for the rest of their lives. Our department has seasoned officers, people who have spent decades on the job, who struggle to sleep, break down in private, and question how something so cruel could happen. Some sought counseling, others withdrew, and all were changed. In policing, we learn to build emotional armor, but this case pierced through it completely. The impact extended far beyond the station walls. The community where we serve was shaken to its core. Parents became fearful, neighbors grieved together, and many questioned how such violence could touch the life of a young child. The officers who patrol these streets now do so with heavier hearts, knowing that the unthinkable is possible even here in North Olmsted. For months, our investigators worked tirelessly, reviewing the case and collecting evidence. Every step of the process was fueled not just by duty, but by a deep personal drive to bring justice for a little boy who could not speak for himself. This case has reminded us all of both the fragility of life and the weight of our responsibility as protectors of our community. It has strengthened our resolve, but also revealed the deep emotional cost of what we do. On behalf of the North Olmsted Police Department, I ask the court to recognize that this crime did not only destroy one young life, it profoundly affected an entire community and the officers sworn to serve it. Justice in this case is not only about punishment, it is about acknowledging the immense harm done and ensuring that such tragedy is never repeated. Thank you.
Thank you. Ms. Feralia?
Thank
Ms.
you,
Patel?
Your Honor. The overriding purposes of felony sentencing are to protect the public from future crimes and punish the offender. The state, Your Honor, is going to ask you to impose the maximum penalty allowed by law in this case. Life without parole for Julian Wood and consecutive time for Margot Wood. Your Honor, you sat with us for 8 days and learned about Bionca Ellis. She had no regard for human life when she stabbed a vulnerable 3-year-old child sitting in a shopping cart. She stabbed him to death after hunting him down. She targeted him. And I'm sure, Your Honor, you remember how this defendant selected her weapon of choice. She left Volunteers of America with 2 knives in her hand. She goes to Things Outlet, and you observe her on the video searching and looking around with knives on her back, behind her back. She walks out, and she goes to a cement column to check out the pliability of the knife. continues to walk into Giant Eagle, passing people on both sides of her. But once she sees Julian in a shopping cart and Margot pushing that shopping cart, she does an immediate about-face, and she follows them closely behind. Mrs. Wood stops. The defendant continues to walk past her. But she waits. She waits at the foyer of Giant Eagle, the entrance. As Margot and Julian pass her by, she gets right behind them. She resumes walking behind them through the parking lot until she gets to Margot and Julian, and then you know what happens next. When a murder occurs in our community, folks want answers. When a murder occurs, the victim is able to fight back, yet they succumb to their acts. They succumb to their attack and they die. What is unique and so heinous in this case is that a defenseless 3-year-old who had absolutely no ability to fight off his attacker was slaughtered by this defendant, and he succumbed to his injuries. The surveillance video of Giant Eagle demonstrates that this defendant carefully chose her victims and executed her plan. Her egregious actions demand the most punishment allowed under the law. You know, Judge, words are bantered about in courtrooms daily. As lawyers, we choose our words carefully. We have word choices, we have pronunciations, we have inflections in our voices. And we have a jury system made up of common, ordinary people who walk into this courtroom not knowing what case they are going to sit on. But that jury system is the crux of our legal system. The jury in this case chose its word carefully, and they found Bionca Ellis guilty of all counts. They rejected the not guilty by reason of insanity at the time of the act, indicating that this defendant knew the difference between right and wrong. Now, Judge, we stand before you and ask you that in a civilized society, we, the people, rely on the recourse of the law. We take an oath to uphold the law. Now it's time to impose punishment for breaking the law. When I hear the word mercy, mercy is given by God. Courtrooms, judges dispense justice. Society, Judge, cannot afford another Bionca Ellis harming another Julian Wood or Margot Wood in this community. I know that you will take everything into consideration. And I know that you will do what society demands and what this family deserves. Thank you.
Thank you. On behalf of Ms. Ellis? Yes. Thank you.
Judge, thank you, first of all.
The microphone was turned off. Thank you.
Can you hear me?
Sure.
Okay.
I could have heard you anyways, but I just want to make
I
sure.
thought so.
Yeah, thank you.
As you know, these are unique trials when the defense is not guilty by reason of insanity. Not unlike a capital murder case, you get to hear the mitigation during the course of the trial. And what we learned is that Bionca's 34 years old. She has no prior felony convictions. We accepted responsibility in this case. We acknowledged it in voir dire, in opening statement, and then in closing argument. She allowed for us to have that as a part of her defense. And we know that she's remorseful. You heard the testimony of Dr. West. She told you that once Bionca learned what had occurred, she was tearful. She expressed it. And throughout the course of this trial, Bionca demonstrated good behavior. She was polite. She never got out of pocket. And that is Bionca on medication. And that trial lasted for 8, 9, 10 days. If nothing more, we learned that she's two different people. It's like Dr. Jekyll and Mr. Hyde. When she's medicated, this is what you get. When she's not medicated, what happened on June 3rd, that's a different version of Bionca. Now, typically at this stage, as defense lawyers, we capitulate, we talk about responsibility, we talk about remorse. And what I want to say is this. Mr. Johnson and I respectfully disagree with the verdict. And while we have tremendous respect for that family back there and the courage that they've shown, the civility that they've demonstrated throughout the course of this trial, and respect for the state and law enforcement who did a great job in this case, although we accept the verdict, we respectfully disagree with it. And what I'll say is that you have to decide the worst form of the offense when you are sentencing. And we all know that all the experts in the case agree that Bionca was mentally ill. You know she suffered from a severe mental disease. There's no question about that. And that we all know that from at least January of 2024, all the way up until June of 2024, she was unstable, she was hospitalized, and she was not on medication. You had that evidence as recent as maybe 3 or 4 days prior to this incident while she was in the North Olmsted jail. So she's not okay from January to June of 2024. And then once she's arrested and she comes into the arraignment room for the next couple of months, we know that she's incompetent. Somehow, just on the day of the incident, she's not well. And I'm not relitigating this. That's not my intention. You understand that. This is something that you're allowed to take into consideration for purposes of mitigation and deciding whether or not this case is the worst form of the offense. I am firmly convinced that had she been found not guilty by reason of insanity, based on my experience with these cases, that she'd probably be in hospital for the next 20, 30 years. You're allowed to weigh all of that. And she's been in custody for almost a year and a half. When on medication, she's been on custody without incident. I don't know if they want me to point them out, but she's had strong family support throughout the course of this trial. And looking at the sentencing factors under 292912, I think that there's a lot of mitigation in this case. And I know how powerful these facts are as it relates to the death of a child. And I know it's a very weighty decision for you. But judges don't make decisions based on emotions. You follow the law, you look at the sentencing factors, and then you make a decision based on her history and her characteristics. You make a decision based on what you know about her. So both Mr. Johnson and I respectfully ask the court to consider 20 years before she's parole eligible to a life sentence and sentence her accordingly as it relates to Margot's injuries. Thank you.
Thank you. Mr. Johnson, anything? Anything on Ms. Ellis would like to speak?
I just want to say I apologize. I'm really sorry for what happened.
Okay. All right, you can be seated. Thank you. Justin, don't mind just pushing it right up to me so it's out of the way. Thank you. Thanks for doing that. So with respect to sentencing, so I have some comments that I'd like to make. You know, I think it's fair for all of you to understand, just as the lawyers have pointed out, there are certain guidelines I follow as a judge. And some of those things that are said are mitigating. Others I take into consideration, just like any other of my fellow 33 judges here on the bench. You know, sometimes the word is desire and demand. You know, those are not in the revised code section 292911 or 292912. I don't say that to minimize any of the comments that were made, but I do take in everything, right? So I don't come up here on the bench without some idea of what the court may use as the tools under the revised code section to move forward with sentencing. And so I'll say to the Woods family, nothing I say here will ever capture the enormity of your loss. This court recognizes that your lives were forever changed on June 3rd of 2024. Understanding your comments, I thank you for them. No sentence I impose today will make you or your family whole again, and you know that. I do want you to know that I acknowledge, even similarly as Mr. Mack said, your courage, your hopes, and today my hope is that this brings some measure of closure for you to continue to move on in your lives. As you continue to navigate the landscape of life without your son, please know that I'm painfully aware of Julian's void in your lives. Justice cannot undo tragedy, but it can affirm that what happened was wrong and that your child's life mattered. And to the Ellis family, you've been here the whole time as well. I do want to acknowledge that this process as well has been painful for all of you. As a family, you must forge ahead and try to understand the nature and gravity of this case. Again, while my sentence must reflect the severity of the crime, I do not ignore that your family too are experiencing loss. And I hope that you find strength in the days ahead. Ms. Ellis, as noted, the jury of your peers has spoken. They have found that although we all have agreed that you suffer from schizophrenia, that you did understand the nature and wrongfulness of your actions as handed down in all of the guilty verdicts by this jury. You know, the power of the American jury system is that it reflects the values of all the community that they represent. And as I sit here as a judge for almost 21 years, as a court, I accept the finding of your peers, and I'll sentence accordingly. You know, the tragic sequence of events of June 3rd of 2024 and that attack, the jury has found was calculated and wholly without justification or reason of any kind. You know, I rewatched every video for preparation for sentencing that was presented during the trial. And I find that it's clear that in that evidence, you are fixated on the very first child that you crossed paths with that tragic day. That tragic day, you chose to end the life of Julian Wood. A life, as we heard today, that was filled with limitless promises. Your choice has inflicted immeasurable pain on the Wood family, on your own family, and as we heard, on the community in which we all live. Mental illness does not excuse what you did. although it'll be taken into consideration when you are sentenced, that you continue to receive ongoing treatment while incarcerated. Ms. Ellis, I hope that you use this time to confront the harsh reality of the actions that you've created here in the courtroom. No sentence that I hand down today can undo the pain that you cause, but justice requires that your actions have consequences. Before concluding with my sentence and outlining what I will hand down today, I do want to take a moment to address an issue that confronts this court and our communities near and far. This tragedy did not occur in isolation. As a society that cares for the members of the community, we cannot continue to ignore the glaring gap in our county's mental health support system. It is not lost on this court that this trial started during Mental Illness Awareness Week, a week that recognizes the importance of meaningful connections, advocacy, and local actions to ensure that adequate mental health services are available to each and every citizen here in Cuyahoga County. Significantly, the medical experts in this case testified on October 10th, a day that was globally recognized as World Mental Health Day, a day that's dedicated to raising awareness around mental disorders and combating their social stigma. It's in this spirit I hope we all continue to confront the gap between the need for mental health treatment and its effective and equitable distribution and provision to all of those in our community. And therefore, I urgently implore our city and county leaders to continue providing facilities and programs that respond quickly and compassionately to those in crisis. The need is dire now than far too many of us realize. The leaders in this county have been discussing this topic for far too long. Please get it done. No family should have to lose a child, and no family should have to watch their loved ones deteriorate because meaningful and effective mental health services were unavailable. The absence of adequate and functioning mental health facilities in our community has tragic consequences. And I call upon our leaders at every level of government to make providing and supporting mental health care a true priority so that others in crisis can be helped before another tragedy occurs. But Ms. Ellis, again, I want to state that while your mental illness was accepted by this jury, it is not an excuse for what you did. The jury found that although you suffer from schizophrenia, you understood the nature and wrongfulness of your actions and handed down their guilty verdict on all charges. When reviewing the sentencing factors as outlined under 29-29-11 and 29-29-12, my job as a judge here is to punish the offender, but also to make sure that the sentence should be proportionate and not demeaning to the seriousness of the offender's conduct and the impact on the victims, and consistent with other sentences with similar crimes. In looking at the seriousness, of course, the child's age and the suffering weigh heavily for this court as well. And so with respect to my sentencing, after taking in consideration all the matters before the court that are appropriate under the principles and purposes of sentencing, the court's going to impose the following sentence. Starting with count 2, as found guilty on count 2 of murder, it's a life with parole eligibility at 15 years. On count 3, the murder charge under the B section, it's life with parole eligibility at 15 years. And those are the maximum sentences that could be handed down on those 2 counts. On count 4, with respect to the Reagan-Toke sentencing guidelines, count 4 and count 8 are both felonies of the second-degree felonious assault. We also speak to count 5, which was the endangering children as a felony of the second degree. And then we speak to count 7 and 6. The state and I have agreed that I will move forward with count 7. Under count 7, under the Reagan-Toke sentencing guidelines on the attempted murder in count 7, court's going to hand down the maximum sentence of 11 years as the minimum sentence to the indefinite sentence of 16 and a half years. Again, I've outlined the Reagan-Toke guidelines and the reporting requirements for post-release control that will be controlling on all other felonies of the second and first degree, this being the highest level. I've outlined the 5 provisions, as I noted for the record already. And then with respect to the count 4 and 8, the maximum sentence is 8 years. I'll hand down that sentence. Count 5, 8 years. Count 6, 11 years. Count 8, 8 years. And then, as indicted, count 10, which would be a 6-month sentence on the misdemeanor charge. Regarding aggravated murder and finding the defendant guilty of aggravated murder by this jury, the court's going to hand down a sentence of life without parole. I'll run every other sentence concurrent to life without parole. Ms. Ellis, you'll be given credit to 509 days of the time that you've served. I'll order you in the custody of the sheriff to transport you to Marysville Correctional Facility. I'll also indicate that fines, fees, and court costs will be waived with respect to this sentence. In addition to the verdict that has been handed down by this jury and the sentence that the court handed down, Ms. Ellis, you have a right to appeal both the sentence and the conviction in this case. You can do that by filing a notice of appeal with the clerk of courts within 30 days of this sentence. If you're unable to pay for the costs of an appeal, you have the right to appeal without payment of costs. If you're unable to obtain counsel for an appeal, I'll appoint counsel to represent you. If you're unable to pay the cost of documents necessary, they are provided to you without cost. You have a right to a notice of appeal filed timely on your behalf. And Ms. Ellis or counsel, do you wish to appeal both the sentence and the conviction handed down in this case?
Yes, Your Honor. Note our objection for the record and appoint counsel for the appeal.
I'll note your objection regarding my sentence, and knowing that she's unable to afford counsel, I'm going to appoint the public defender to represent her with respect to her appeal. Again, noting for the record, all counts will be run concurrent to each other, with the life without parole being count 1 sentence. I'll waive all fines, fees, and court costs, give her credit for the 509 days that she served, in addition to time while she awaits her transportation to Marysville Correctional Facility for Women. Is there anything further from the state of Ohio before we recess?
No, Your Honor.
Anything on behalf of Ms. Ellis?
No, Your Honor.
All right, we adjourn. Thank you.
Yeah.
it all set here. Thank you so much.
Here. As I discussed before, we have tremendous respect for the process, the jurors' verdicts, that family in there, what they've gone through. No one wins in this situation. But I meant it when we said that we respectfully disagree with that verdict. And, you know, you have to understand that because demonstrated mental illness all the way up until that day. Somehow just on that day, she's not mentally ill. And then following, we had to have her restored. We couldn't even communicate with this woman. So just one day out of 6 months, 8 months, she's okay. So we push back a little bit on that. And the difficulty with this kind of case is that jurors don't have the opportunity to understand that not guilty by reason of insanity, it doesn't mean that a person walks back out into the street or into the parking lot like what they think. We're not allowed to discuss that during the course of a trial. So that is certainly a disadvantage, and we just hope that the law changes as it relates to that aspect of it, because this kind of case is so unique that jurors should know that hospitalization could last as long as a prison sentence could last. And until they know that, it's going to be difficult because no one's going to let anyone walk back out into the street after having taken the life of a 3-year-older. So that's what I say, and you know, again, we respect the process, and she has a right to appeal it.
And you are appealing, correct?
Yeah, the
That's
public
correct.
defender has been appointed, so.
Yeah, I mean,
we're aware.
I know that somebody else will be handling that, but, and it sounds maybe obvious to some of us, but on what grounds would the appeal be?
Well, I mean, the appellate lawyer would have to look at the weight of the evidence.
Manifest weight and sufficiency of the aggravated murder. She didn't plan that murder. So when you talk about prior calculation and design, there was no prior calculation for her to go into that grocery store. But for a few things happening, Ms. Woods would not even have been there. So I think manifest weight and sufficiency, and the public defender does a great job at doing appeals, so they'll look for whatever avenue they can appeal.
And just to be clear, is she appealing her conviction and sentence, or both? Both.
Both. And the other thing that I'll say about this is that, I mean, as you stand here, you all followed the trial. What is the rational motive in this case as to why she took that child's life? And if the answer is because she was angry about money not coming back from the police, then again, we push back a little bit with respect to that, so.
She didn't say much. What did she say to you before you came out there or after, at the end here? I mean, I guess maybe the question I'm really trying to ask is, why didn't we hear more from her?
Well, I can't tell you what she and I discussed, or what she discussed with Mr. Johnson and I, but we know that she's remorseful, and we know that she feels horrible about this event, and that's probably where I should leave it.
Thank you.
Yep.
Thank you.
I'm so sorry, I'm sorry, my big head.
She does not.
Ed's trying to watch TV. We're tall.
She used to come down with the Giant Eagle.
One second, yeah.
Can I stand? That was too hard for me. I apologize. I'm not gonna go. Yeah, I got you.
Thank you.
Well, thank you for all coming this morning. I think justice was served in this case, folks. I think mental illness is a real issue in our community, and I think the judge brought that to light. But I also believe that good people that come down here and do jury service and care about their community spoke loud and clear in this case. We have never disputed that Miss Ellis had a mental illness. There was never a dispute to that. The dispute was, did she appreciate the wrongfulness of her actions? The jury saw through all that. You folks were here with us. You listened to the testimony of the doctors. If we can't rely on doctors, who can we rely on in making our case? So the kudos really are not for us or the prosecutor's office. The kudos are for the doctors that spend painstaking time meeting with these folks and making their decisions. So thank you to the community and thank you to you folks.
And I know you've tried a lot of difficult cases, but was this one of the most difficult?
They're all difficult when they are with children. Children mean a lot to this community, as do the elderly. They're vulnerable folks. They need a voice. And I guess for the last so many years, I've been their voice. And my colleague and I were privileged to have been assigned this case and to prosecute this case. But every children in this community means something. And if we're their voice, then so be it. We're their voices.
Today we literally heard the family let out a sigh of relief after the sentence was read down. Can you explain just what this means to them?
I think it means to them that Julian will never come back, but they can rest assured, and their neighbors can rest assured that somebody else in the community isn't going to be doing what Bionca Ellis did, with or without a mental illness, folks. I mean, these were people that were going grocery shopping to make supper for the dad who was coming home from work. How many people in our community do this day in and day out? And unfortunately, she wasn't able to bring that little boy home because of one person's actions. So the sigh of relief, you know, we never give families closure because we can't bring anybody back from the dead. What we ensure is that punishment is dispensed and that it's dispensed fairly. This is not about anything else but someone who killed a child.
What did you think of Bionca's apology?
It was her right to do that.
And North Olmsted Police, their investigation was very helpful to you.
Oh, their investigation was thorough. Everything, they unearthed things about Bionca Ellis that she probably didn't know she had in her background. They were very, very thorough. They were very, very committed. And like the detective said, this affected even the most senior members of their police department. When a child's involved, you guys, it just changes the dynamics for everybody, whether prosecuting or defending. It just changes the dynamics. It always has and it always will.
Thank you.
All right, thank you.
It doesn't make sense to stay here for 2 hours. Jinx, buy me a Coke.
Maybe we can stop at a smoothie shop on the way home.
A smoothie shop?
Restore on Prospect.
Wherever we want to go.